Contracts are promises that courts will enforce, and contracts are formed when there is offer, acceptance, and consideration. But even when contracts are formed under these legal principles, parties might assert certain defenses, which, if proven, can cause the contract to be voidable and not enforceable by courts. In this lesson, we're going to review several defenses to contract formation. Mistake, which can be either bilateral or unilateral. Misrepresentation, which can be material or fraudulent. Duress, undue influence, public policy, and finally, unconscionability. It's important to know these are equitable principles. The picture on the right shows a classic court of equity. It used to be that courts of law and courts of equity were separate, and if you couldn't get redemption in a court of law, you could plead your case in front of an equitable judge. We don't have that system anymore, but some of the vestiges remain. These claims, being equitable, are only implemented when the interest of justice so requires. And so facts and circumstances are very important in determining whether these defenses will be available. The defense of mistake is when there is a belief that is not in accord with the facts. To understand mistake, we have to learn what is a basic assumption, what is a material effect, and what is the risk of mistake. For example, a basic assumption of getting a life insurance contract for someone is that the person is actually alive. On the other hand, some things are legally found not to be basic assumptions in most cases, such as market price. But even if there was a mistake regarding a basic assumption, it still must have a material effect on the bargain. For example, let's say A and B agree to buy and sell a tract of land, which they both believe is 100 acres, at a price of $1,000 per acre. It turns out that the tract contains 110 acres. It would seem this would not have a material effect because the parties could simply pay an additional $10,000 and honor their contract. Finally, the party asserting the defense must not have taken the risk of mistake, which can be allocated by law or by contract. There are two types of mistake, unilateral and mutual. A mutual mistake is when both parties have the same belief that is not in accord with the facts. In order for a contract to be voidable because of a mutual mistake, that mistake must be as to a basic assumption. It must have a material effect on the transaction, and the party asserting it must not bear the risk. In this case, the contract is voidable. A unilateral mistake has additional requirements. Yes, you have to have a mistake as to a basic assumption, which must have a material effect, and the party asserting it must not bear the risk. But in addition, in the case of a unilateral mistake, the court must find that enforcement would be unconscionable, or the party not asserting the defense who wishes to enforce the contract knew or should have known or caused the mistake, in which case it would be voidable. How can a party bear the risk of mistake? Simply, it can be allocated by agreement. For example, let's say you contract to buy a house as is. In doing so, you've probably assumed the risk that the roof is not in great shape. Risk can also be allocated to a party who is aware that they have limited knowledge but treats that knowledge as sufficient. For example, you might go to buy a used car, and you know that when you buy a used car, you should get a Carfax report to see if there's been any damage. And you don't get this report. But you look at the car and you decide that it looks like it hasn't been in an accident, and so you determine not to get the report. In this case, you know you have limited knowledge. That is insufficient. But since you treated that knowledge as sufficient, you might bear the risk of mistake if the car in fact has been in an accident. Finally, courts might put the risk of mistake on one party or the other when it's reasonable under the circumstances. Our next defense is misrepresentation, which is a statement not in accord with the facts. Recall a mistake is a belief not in accord with the facts. Here we have a statement. That statement must be either fraudulent or material, induce actual reliance, and that reliance must be justifiable. Sometimes an action can be considered a statement under the misrepresentation doctrine when an action is taken to prevent another from learning a fact. Taking an action that prevents another from learning a fact is called concealment, and it's equivalent to stating that that fact does not exist. For example, you go to sell your house, and there's a big crack running through the basement. To prevent the buyer from seeing the crack, you paint it over. By concealing the crack, you've effectively made a statement that the basement is sound. Finally, sometimes doing nothing can constitute a statement. It's unusual that inaction and non-statement or silence can be considered a statement, but there are 4 specific instances. Where a party knows that a disclosure of a fact is necessary to prevent a prior assertion they made from becoming untrue, there is a duty to correct what has now become a misrepresentation. Second, when a party knows that disclosing a fact is necessary to correct another party's mistake as to a basic assumption, which is a reason the party is entering into the contract. If non-disclosure of that fact amounts to a failure in good faith and does not comport with reasonable standards of fair dealing, there is a duty to correct that mistake, in which case non-disclosure can be a statement. Third, where a party knows that disclosure of a fact would correct a mistake of the other party as to the contents of a writing. And fourth, there might be a duty to disclose when the other person is entitled to know of a fact because of a relationship of trust and confidence between them. To have a misrepresentation, we must find that that statement is fraudulent or material. A fraudulent statement is one that is intended to induce assent, and the maker knows or believes the statement is in fact not true, or the maker lacks the confidence implied by the statement, or the maker knows that there is no basis for making this statement. Let's go back to that car example. Let's say you're selling a used car on a car lot, and you haven't pulled the accident report, even though you know full well as a used car dealer that these reports contain important information. Not knowing whether or not the car has been in an accident, you say to the buyer, "This car has not been in an accident." This is almost certainly a fraudulent statement, even though you don't know that it's not true, if it turns out not to be in accord with the facts, because you had no basis for making the statement, and you reasonably should not have had the confidence to make it when you had not looked at the reports. A material misrepresentation is one that is likely to induce a reasonable person to enter into the agreement, or when the maker knows it's likely to induce this specific person to enter into the agreement. But just because a statement is fraudulent or material is not enough to make it avoid a contract. You do need to show a statement is fraudulent or material, but you also need to show that the party asserting the defense is justified in relying on it. Reliance is generally justified, although there are exceptions as to relying on statements of opinion, matters of law, or statement of intentions in the future. The issue really comes up when the party who is trying to assert that they relied on the misrepresentation was at fault. In some situations, a party might have the obligation to suss out the facts and circumstances, and is not entitled to rely on statements by the other party. But in general, when a person makes a fraudulent misrepresentation, a statement that that person knows or doesn't have the basis to make because it is not in accord with the facts, generally, that's enough to void a contract on the basis of misrepresentation. Our next defense is duress. If you put a knife to their neck and demand they sign a document, that signature was not a manifestation of mutual assent, but merely compelled by duress. In the case of physical duress, the law holds that there is in fact no contract. But improper threats can also make a contract voidable, where there is no reasonable alternative than to succumb to the threats or assent to the contract. Improper threats include threatening a crime or a tort, threatening criminal prosecution, threatening a lawsuit without having a good faith reason for filing it, or threatening to breach the duty of good faith and fair dealing that's found in all contracts. Our next offense is undue influence, and we find this comes up often in family relationships. It requires unfair persuasion to a person who is under dominion of another. For example, Al, an elderly and illiterate man, lives with and depends for support on Betty, his niece. Betty tells Al that she will no longer support him unless Al makes a contract to sell Betty a tract of land. Al is thereby induced to make the proposed contract. Even though Betty's conduct does not amount to duress, it amounts to undue influence because Al is under the dominion of Betty, and so the contract is voidable by Al. Our next offense is for public policy reasons, and this is a balancing test that we employ. On the one hand, let's look at reasons why we would enforce a contract on the grounds of public policy. We want to meet the parties' expectations. Courts generally want to enforce contracts. We look at whether the parties would forfeit certain rights that they were expecting, and to the extent that those forfeitures are excessive or unfair. And we look at whether there's any special public interest in enforcing this particular agreement. On the other hand, reasons against enforcement include the strength of a policy that might counsel against this. To what extent refusing to enforce this contract furthers that policy, and whether there was any misconduct involved in the parties coming to this agreement, and whether that misconduct was directly connected to the term in the agreement that is being challenged. One common example of this is that you cannot force someone to work for you for an unlimited period of time. Ever since the Emancipation Proclamation, this has been in direct contravention to public policy in the United States, and so courts will not enforce these type of agreements. In fact, courts are reluctant to enforce any agreement requiring anyone to work for similar reasons. Finally, sort of as a catch-all, courts might not enforce an agreement when doing so would be unconscionable. Unconscionability doesn't come up that often, but it can be a reason not to enforce a contract where there is a significant asymmetry in the bargaining positions between the parties that results in a gross disparity in the value they receive. This is not so different from violating public policy, and sometimes public policy and unconscionability are discussed in the same case. I hope this recap has helped remind you about the defenses in contract formation. I'm Professor Seth C. Ornberg. Thanks for listening.